Ms. Sondi, your mic is muted.
Apologies for that. Somebody muted me, one of my co-hosts. Mr. Are you on standby? Thank you very much. We are actually going live. I would like to welcome everybody to the session. Good morning to all the participants, everybody that is participating today. We invite you all as the Information Regulator South Africa. And we would like to say Happy International Data Privacy Day and welcome to this webinar. My name is Nomzamo Zondi. I'm the Information Regulator. I have been tasked today to facilitate the session with the regulator. So you are most welcome. I would like to indicate to everybody that we are live on Facebook, our Facebook page, which is the Information Regulator South Africa. I would also like to invite everybody to actually follow our Twitter page, which is @InfoRegulatorSA. And please tweet as we are engaging on today's session. Kindly use hashtag Data Privacy Day 2021, hashtag Data Privacy Day, hashtag Popia. So thank you very much again for joining us today on this very esteemed day. I would like to actually start off our program today by allowing our first speaker, which is going to be our executive member, Mr. Nemasisi, who is just going to welcome to this session and give us a few introduction in terms of who is on our platform today. So then we'll be able to get this show on the road. So Mr. Nemasisi, can I allow you to welcome and introduce us to today's session? Over to you, Mr. Nemasisi.
Good morning, Program Director, and good morning to everyone present at this day. As the regulator, we are very excited.
Mr. Nemasisi, can I request that you unmute yourself?
Can you hear me? I'm actually unmuted.
We can hear you.
Oh, okay, now that's fine. I was saying good morning, Program Director, and thanks a lot for giving us this opportunity. And I would like to say, as the regulator, we're very excited to host the International Day, Data Privacy Day. And this is the very first for for the regulator. And this is an opportunity for us to be able to share with everyone as to what is it that they're supposed to do in order to comply with POPIA. So a very warm welcome to members of the regulator present today. Professor Snail is a part-time member. He's also one of the speakers. Advocate Strom Zama, she's a full-time member. She's also one of the speakers. We've got Advocate Weapon, who will also do the closing. He's a full-time member. Last year, the regulator welcomed a new member, which is Ms. Alison Tille. She's a part-time member. Unfortunately, our chairperson is not present today due to bereavement in her family. And we extend our sincere condolence to the chairperson and her family. I would also like to welcome our esteemed guest speakers, Ms. Avani Singh, she's present, I see here, and also Mr. Mary Hunter. We wish to thank you for partnering with us in this very first International Day of Data Privacy. There cannot be a webinar without our stakeholders present here, who have been with us since the establishment of the regulator, and we're very grateful for your presence, all of you. The information regulator, as you are aware, is established in terms of Section 39 of Protection of Personal Information, which we call it POPIA, which in this legislation enjoins the regulator to be independent, impartial, and to perform its function and exercise its power without fear, favor, and prejudice. The regulator is accountable to the National Assembly, which actually confirms our independence. So there will not be political interference as we perform our responsibility as the regulator. As you'll be aware, the regulator is responsible for the protection of the right to privacy, and this right is actually enshrined in Section 14 of the Constitution. And the regulator is also responsible for the promotion for the right of access to information, which is also enshrined in Section 32 of the Constitution. In this regard, the regulator exercises its power and performs its function in accordance with both POPIA and PAIA. Program Director, of particular importance for purpose of this webinar is your section 14(1)(d) of the Constitution, which provides that the right to privacy includes the right not to have privacy of your communication infringed. It is for this reason that the regulator has decided to host its very first webinar on international data privacy. And this day is intended to empower individuals and businesses. These are, in terms of our industry, we call them data subjects and responsible party, who obviously they need to respect the right to privacy, safeguard of personal information, and to enable trust between the data subject and the responsible party. So that's the main reason why we have this webinar. In this regard, as you may be aware, POPIA prescribed 8 conditions for lawful processing of personal information, and these conditions are the yardstick of POPIA compliance. I'm not going to go into details, as our speakers, I'm sure they will deal with that. Due to COVID-19, the usage of social media and electronic communication increased significantly, and therefore the protection of personal information has become paramount important for the regulator and, most importantly, the responsible parties. As part of its mandate to ensure appropriate protection of personal information, the regulator will be publishing the guidelines on drafting code of conduct, as well as the guidance note on information officer and deputy information. This will be published as soon as possible. Program Director, the regulator is also considering developing the following guidance notes. The guidance note on how to obtain prior authorization from the regulator, guidance note on notification of security compromise or breaches. We also considering the guidance note on application to process personal information, guidance note on application for exemption from the condition for lawful processing of personal information, and lastly, we're also considering a guidance note on processing of personal information across border. This is what we call the transfer of information outside the Republic of South Africa. Program Director, I know we do not have enough time. I will end here, and I would like to thank and welcome everybody present at this webinar and wish the success of this webinar. Thank you so much.
Thank you very much, Mr. Nemasisi, for that welcome and introduction. And thank you so much for summing up very well the role and the mandate of the information regulator, as well as what is it exactly that we are meeting here today for. I would then not waste any time by calling upon, we are very excited to have our new member who joined us in December, Ms. Alison Tilly, who will then be doing our opening address to this session. Ms. Tilly, if I can allow you to take the floor. Thank you.
There we go. Thank you very much. I'm very pleased to be here. Welcome everybody. Our first event for the year, and occasioned by a flurry of discussion amongst us about what it is we are to do about the fact that WhatsApp is wanting people to accept changes to the terms and conditions under which they operate, which appear to have some impact on privacy. We decided to look at social media because it is such a big area, and one, you know, given that we're talking about it now, perhaps we should go into it in a little more detail. The companies that I suppose we really think about when we talk about social media go by various acronyms. My favorite one is GAFA. So Google, Alphabet, Amazon, Facebook, Apple, all of these guys. Those are the really big social media companies. Although perhaps to call them social media companies doesn't really explain the full breadth and depth of what it is they do. They are amongst the most valuable public corporations in the world as measured by their market capitalization. What is it that makes them rich? It's not diamond mines, and it's not oil, and it's not land, and it's not factories. What makes them rich is our personal information. How did they get that information, and how do they make money from it? And is that legal or illegal? One approach to this, and I've always rather liked the image, is that the personal information that they use is the information that we leave behind us as we go through the web. We leave it lying on the ground like a trail of breadcrumbs behind us, and they come behind us and they sweep up that little bit of personal information and they put it all together, and it becomes something new and different and valuable. While I like the image, I don't think it's correct. The reason it's not correct is because that would describe personal data as being a small, low-value thing that you can leave behind you for somebody else to pick up. And of course, that's not quite right. That's not what personal data is. It's not a product of yours. It is you. A better image, I think, which helps us understand what's going on in this particular area is to think about your avatar in cyberspace. So while there's one of me sitting here in the real world in Cape Town, there's another one of me sitting out there in cyberspace. That image, that avatar, every time I go online, that avatar is added to. Now, it can be because I go onto Facebook and look at pictures of cats, which I enjoy very much. It can be when I swipe my bank card. It can be when I claim on my insurance policy. All of these clicks and likes and swipes build up that picture of me in cyberspace. Some of that is public information. Some of that is very private information. And then there's the information in between, the information that I'm happy for you to see, but perhaps not somebody else. Our avatars differ widely. Some of us are just a little dark shape with perhaps a SASA card light or a light from the voters roll. And then there are others of us, probably more like perhaps many of us on this call. We are lit up like Christmas trees in cyberspace. The data that we share, the data sets that have been combined, new insights and learnings about us. The idea with data protection law is that it's supposed to help you manage your own avatar, right? The avatar in cyberspace should be as private or as public as you are in your own life. Privacy is a tricky thing. It's privacy around a particular piece of information is a right you can waive. So if you look at, for example, if I would say, I've done a pregnancy test and look, I am pregnant, and let's just assume it was a test done at a lab for some reason. There should be only two people who have access to that data, me and the lab. However, we know that what happens and has happened previously is that companies have been able to put together data sets and have been able to predict that I am the sort of person, given all of my actions, that I am going to be pregnant. And of course, Target famously got into trouble by then sending people adverts for baby goods to people who either did not know they were pregnant or who were trying to keep that pregnancy quiet. So we have this avatar in the world. We're hoping to keep it correct and looking more or less the way it should.
Join the meeting.
How do businesses make money off that avatar? We used to think it was a relatively simple thing. We show you an advert of a packet of nappies, and you look at the advert and they explain to you why this nappy is a superior nappy, and then, okay, next time I go to the shop, I'll try that one. But it's a very simple and unnuanced understanding of what's really going on. That avatar in cyberspace is beginning to be molded by the GAFA companies, changed in the way that it's in this world. Everything that's happening, those interactions, the likes and the clicks and the dopamine hits are shaping the avatar and shaping our response, I think most importantly, to world events. So we are more and more persuaded to move in a particular, to take particular actions on issues that are much broader than whether you choose a particular brand of nappy. So it's moving whole populations in different ways. There are ways that we try to manage this, and some of that is through legislation. And what we've seen recently is that the whole issue around WhatsApp has really shown up. I think that there are different strokes for different folks, as Advocate Weapon put it previously, that there are different sets of rules for people in different places. And one of this discussion on WhatsApp has showed it most clearly, in that there are some places, European Union member states, that have rights in terms of data privacy regulations, and that WhatsApp appears to be respecting those rights. And those relate to different issues. So an issue like access, and the issue where you can go and ask a controller if they are processing your data, and if they say yes, then I can get hold of the details of that processing and a copy of that personal data. So that would be in terms of the European Union data privacy regulation, or the GDPR. That would also be true of those of us in South Africa in terms of Section 23 of POPI. Those of us who are not inside the jurisdiction of the European Union are not protected by the GDPR. And it may be, and you know, we don't have a view on this as yet, but it may be that the way that these issues are approached in South Africa, it's as though there's GDPR protection in Europe, and then everywhere else there isn't. Because of course we do have protections. WhatsApp has been saying, I think, trying to explain what it is that they're doing and why they're doing it now. I had to go and look at what WhatsApp is actually doing on my phone, because although I use WhatsApp and have used WhatsApp for a while, I really didn't understand what it was that WhatsApp was doing with my data. And I think that's true of many of us when we go online. We know that there's the T's and C's. We know that there's the privacy policy. We click yes mostly because we want to use whatever it is.
The background of this company. That's when they will outline and say, no, this company is empty.
Thank you.
I apologize, Ms. Tilly.
Thank you. So what's going on WhatsApp? One of the things that you'll see is that if you're putting WhatsApp on your phone for the first time, you'll be prompted to agree to a statement which says that WhatsApp would like to access your contacts. Now, this is a very helpful function. You'll know this. You put somebody's number into your phone. They're uploaded as a contact. WhatsApp will then access that contact, and then you can start communicating with that person on WhatsApp. When you do that, you're not just sharing your own information, you're sharing the details of everybody else in your contacts, as I understand it. And it's all of those, it's all of that information. So they may have a phone number or an email address or other contact information. WhatsApp also says it collects metadata. It's one of the ways it's been trying to reassure people, is to say we can't see what's in your WhatsApp messages. Don't worry about that. It's end-to-end encrypted. All we can see is your metadata, which is kind of a problem, because metadata is extremely important and perhaps one of the most under-recognized aspects of your own personal information. All of this going on right now has meant that people are much more aware of what's going on with companies like WhatsApp. And I mean, there are many, many, many different applications that work this way. What we are, I think, looking forward to is to say that it's not just going to be a consequence of you operating in the EU, that you have to operate lawfully if you are one of these companies. You should have to operate lawfully, properly, to use a different way of describing it. You should have to behave properly with people's personal data everywhere. It's not something that is for citizens of the European Union alone. It's for all of us. There have been some interesting decisions which have come out of the European Union, and one in particular out of the Information Commission in the United Kingdom, one dealing with the Cambridge Analytica case, where the regulator there says, in relation to a prosecution against Cambridge Analytica, this prosecution is a warning that there are consequences for ignoring the law. Wherever you live in the world, if your data is being processed, organizations that handle personal data must respect people's legal privacy rights. Where that does not happen, and companies ignore the law, enforcement notices, we will have to take action. So on that note, let me say that I do hope we are able to talk about what the legal implications are of social media and their particular processing of our personal data, but also all the other ways that we process personal data. So on that note, I would like to hand back to Ms. Sondi and to say thank you very much for listening to me. And perhaps we can then move on to our next speaker.
Thank you very much, Ms. Allison. Thank you very much for that insightful opening address. Yes, it was really informative, and it intrigued me when you raised the question, what makes them rich? And you mentioned that it's actually our personal information. So really our personal information is such a commodity. We were ready to have a meltdown when the WhatsApp new privacy policy came out, and it raised a lot of, in fact, it awakened us as most South Africans and users of social media in terms of paying attention of how our personal information is being processed or how is it being used. So it's very interesting what you have actually outlined to us, and even sharing the concept of what is metadata. And I'm actually excited that Mr. Murray Hunter is going to expand on that in terms of what exactly is this metadata. So thank you for enlightening us in terms of what has been happening with the issue of the WhatsApp policy, and what have we been picking up as the information regulator in our process of assessment of the policy. We really appreciate your opening address, Ms. Tilly. Thank you so much for that. So our webinar today, our Data Privacy Day webinar, begs the question, is our personal information safe? So that is what that is a question we are raising today to even our panel members. So we are going to move on to our personal discussions. We are going to first have our first panel member, which is Ms. Avani Singh. Ms. Avani Singh is actually a practicing attorney of the High Court of South Africa, and she's also a certified mediator. She's also the director and co-founder of ALT Advisory and the Power Singh Incorporated. Avani focuses on international and constitutional law with particular interest in privacy, media law, digital rights, and the intersection of law and technology. So Ms. Avani Singh, the floor is yours, ma'am, and we would really like you to take us through the topic of social media companies and their compliance with POPIA. So I would ask if you unmute yourself and also share your presentation with us. You most welcome Ms. Avani to the floor.
Thank you so much. I just want to confirm that you can see the presentation.
Yes, it is visible on our side, on my side at least. So
Great.
Everybody else can see it. You're most welcome.
Thank you so much. And thank you so much for the invitation to be here and participate in this webinar today, which I think is so important. And I'd just like to repeat what was said right at the beginning, that this is a particularly happy World Data Privacy Day, because we can finally say that the Protection of Personal Information Act is imminently around. And in due course, we will be able to start enforcing our rights as data subjects and hold responsible parties to account. So it's certainly a welcome development, and I think the information regulators to be commended on the work that's been done so far in getting ready for POPI's arrival. So I was asked to look specifically today at the intersection between data protection and social media platforms. And what I want to do is kind of go through a few examples from other jurisdictions where social media platforms have been held to account by data protection authorities in those jurisdictions, and draw out some of the key principles that have arisen from these different cases. And at the end, I want to turn to look at a few of the key opportunities and challenges that this presents, both to the information regulator, but also to those of us who are privacy advocates, civil society, academics working in the space, to do our part in strengthening the mandate of the information regulator and raising awareness in broader spaces so that people are aware of their privacy rights. So just to put this in context, I suppose we know that there's a tension between the right to privacy and what we share online, and between the right to privacy on the one hand and what's being shared online. But despite these numerous instances of privacy breaches and serious concerns with the ways in which our data is handled and managed, the reality is that social media use around the world continues to grow significantly. There's a significant prevalence of social media in our society, and it's really a hallmark of this period of the digital era. In July 2020, there were approximately 3.96 billion active social media users across the world, with an annual growth in the number of social medias numbering 10.5%. In South Africa, there are over 22 million active social media users, which is estimated to increase to 26 million by 2025. And the role that social media plays in our society is actually quite a critical and important one. It's important to the way we communicate, the way we engage, how we learn, how we play. It's connected people across boundaries, and it's really had a phenomenal impact on many people's lives. But at the crux of this is that those people who choose to use social media platforms should be entitled to do so safely and securely, be entitled to make informed decisions about the data that they share, and have accountability and redress for any wrongdoing that results from irresponsible or unlawful processing of their personal information. As has already been mentioned, the right to privacy is a critical and fundamental right, both in itself, but also as an enabler of a range of other rights, particularly fostering the right to dignity, autonomy, agency, and so on. It is an inherent protection of who we are as people in our most intimate moments. But it's also an intangible right. It's quite complex and nuanced, and for a long time has been overlooked and not received the protection and attention that it deserves. The Constitutional Court has explained that the right to privacy exists on a continuum, whereby the expectation of privacy is reasonable in the inner sanctum of a person or the truly personal realm, but becomes attenuated the more a person interacts with the outside world. And when we put this in context, there's a wide range of personal information that's being collected by social media platforms, some of which we voluntarily hand over, some of which we're quite unaware of, ranging from our preferences, our likes and dislikes, sexual orientation, health information, location, and so on. And I'd really encourage people on this webinar to go to the social media platforms that you're on and download your personal information to see the reams of information that have been collected about you over the period of time. But increasingly, I think there's a recognition that the right to privacy needs to be respected, protected, and promoted. And this is important for a number of reasons. As I've mentioned, it's a fundamental constitutional right enshrined in Section 14 of the Constitution, and it's imperative, therefore, on both the state as well as private entities to adhere to this right. There's also been a global trend towards data protection and privacy protections, not just in the European Union and increasingly in the United States, but also in the region. Across Africa, a number of countries are adopting data protection legislation. It facilitates the flow of information in a reasonable and responsible manner and makes it possible for information to be protected whilst not seeking to stifle the sharing of that information. For many organizations, data protection is now simply a business imperative. As Alison has already mentioned, the example of WhatsApp, according to the UK Parliament's Committee on Home Affairs, over the first 3 weeks of January, Signal gained 7.5 million users and Telegram gained 25 million users as a result of WhatsApp's change in their privacy policy because of people's concerns over their privacy rights being violated. And of course, there are consequences for non-compliance with the provisions of the law. As we know, there are civil, criminal, and administrative penalties set out in papier, with the information regulator being empowered to issue a fine of up to 10 million rand. But the reputational harm can be even more significant. And that's something that I think more and more organizations are paying heed to and are deeply cognizant of when they decide how they're going to be processing information. At the crux of privacy is this issue of agency and autonomy over the information that we hold and over the information about us. And increasingly, we're finding that users are demanding agency and autonomy over their personal information. People want to know what's being collected about them, who it's being shared with, how it's being used, and for how long it's being retained. This is all the more important when dealing with children, where there's a potential for a lifelong digital footprint that can affect them for years to come. But as I've mentioned, what we see is a fundamental tension between the generation of data by individuals and the sharing of that information, and the use of that data by a range of organizations, including social media platforms. This is exacerbated by terms and conditions that are long and complex, drafted by lawyers in different jurisdictions, and not really fit for purpose and don't meet the requirements of consent and the processing conditions that I'll touch on in a moment. So as we know, there are 8 conditions at the heart of POPI. And I want to focus, when we talk about data protection in the context of social media platforms, I want to focus on 4 conditions in particular that I think bear highlighting. The first is the issue of processing limitation, which provides that processing must be done lawfully and in a reasonable manner, and that there must be a justification for that processing, which might include, for example, consent or a legitimate interest. An example of where an organization has fallen short of this requirement is in the Cambridge Analytica scandal that broke, where the Information Commissioner's Office in the United Kingdom issued a fine to Facebook in the amount of £500,000, which was the maximum penalty at the time prior to the General Data Protection Regulation coming into force, for a lack of transparency in the way in which they conveyed the purpose for which the information was being shared. The second condition that I'd like to highlight is purpose specification, which requires that personal information must be collected for a specific, explicitly defined and lawful purpose and not be retained for longer than is necessary for that purpose. And again, a key example here is the decision of the Court of Justice of the European Union in the Google Spain case, which established what we now refer to as the right to be forgotten, where it found that certain results listed on the search engine's listings or directory was outdated and should be delisted by Google in order for compliance with the data protection frameworks at the time. Openness is another key condition that I think is fundamental to the framework created by POPI. And this requires that responsible parties take reasonably practicable steps to ensure that the data subject is aware of a range of things. For example, what information is being collected, the purpose of collection, and with whom it's being shared. In the case of W, the Belgian Data Protection Authority found that what the social media platform was doing was applying an invite a friend function. In essence, I could share the contacts of any of my friends for certain benefits on the platform without necessarily notifying my friends that I was doing so. And here, the Belgian Data Protection Authority fined W, the platform, an amount of 50,000 euros for implementing the system for failing to meet the openness criteria in terms of how data was being collected and subsequently shared. And lastly, pivotal to the framework is the issue of security safeguards, where responsible parties must secure the integrity and confidentiality of personal information in its possession and under its control. In December 2020, the Irish Data Protection Authority fined Twitter 450,000 euros following a breach resulting from a bug in the design, which allowed protected tweets to be changed to unprotected tweets. And here, one of the key issues was that on becoming aware of the bug in its design and the data security breach, Twitter failed to notify the Data Protection Authority in due course or in a timely manner, and therefore was in violation of the General Data Protection Regulation. In practice, what we find is that data is shared in a number of different ways by social media platforms, whether that's through third-party access, through data breaches, through the APIs, and so on. In some instances, this is done deliberately by the platform, and in others, it's done because of negligence or a failure to take appropriate safeguards to protect the personal information, resulting in data breaches as a result. But what we now know is that there is significant real-world harm that comes from this data sharing, whether that's through the profiles, whether that's through profiles of people being created, whether that's through stalking or identity theft. The range of harms are innumerable. And I think increasingly we are becoming aware that there is an imperative on social media platforms and all responsible parties to ensure the data security and the protection of personal information by complying with the conditions for lawful processing. What I want to spend a little bit of time talking about, though, is the issue of consent, because the answer often is, well, so what? You signed up for a service that was free, and you got, and in exchange, you received certain accesses to a platform that you wanted to use. What are you complaining about? Consent is defined in POPI as a voluntary, specific, and informed expression of will. The General Data Protection Regulation in the European Union goes further than this and adds in the requirements that this should be unambiguous and freely given. And there have been a number of decisions from different jurisdictions, particularly in the European Union, around the requirements for consent. In particular, I want to highlight two decisions that are of particular relevance. The first is a decision by the French Data Protection Authority, the CNIL, versus Google, where Google was fined 50 million euros for having a consent process that was unduly onerous, spread across different documents, and contained pre-ticked boxes in order for persons to consent. One of the key findings of this in this decision was that giving consent, it shouldn't be a laborious process of having to withdraw that consent or to customize the way in which you're granting that consent to certain privacy protections. And that was a really important decision in framing the debate around what appropriate consent looks like in the context of data protection. Subsequent to that, a number of other jurisdictions, including the Court of Justice of the European Union, have confirmed these principles, particularly the idea that pre-ticked boxes are not permissible and do not constitute valid consent. Most recently, in a really interesting judgment, in a really interesting ruling in January 2021, the Norwegian Data Protection Authority issued an advance notification of an administrative fine against Grindr, which is a dating app, which collects various data, including information about sexual orientation. And here, the Data Protection Authority has, in the advance notification, indicated an intention to issue a fine of 10 million euros, which they held to be both proportionate and, very importantly, seeking to be dissuasive of future conduct acting in contravention of the data protection framework. Some of the key principles that came out of that ruling was that consent is not considered to be freely given if you do not allow separate consents to different processing operations. Responsible parties cannot bundle different processing operations and purposes into one globular statement, which just requires a single action on the part of the user without being able to distinguish between these different facets. Where there's a complexity in opting out of a particular service or a particular functionality of that service, consent was considered to be not freely given. And it's one of the key discussions in the ruling is that consent must be able to be withdrawn without detriment to the user. What the ruling stated was that in the instance of Grindr, there was not sufficiently granular access to services in the free version of the app was illegally made dependent on consenting to behavioral advertising, and data subjects could not refuse or withdraw consent without detriment. They failed to present the consent forms in an accessible manner, and therefore the consent was not considered to be informed. And so if you apply that to the number of social media platforms to which you've ticked a single box or clicked OK, you can start to see a picture forming of a trend in trying to obfuscate the realities of the data sharing and data processing activities that are taking place. And I look forward to a time when we can start testing these principles in the South African context and understanding how the South African information regulator will interpret these principles and whether they will similarly apply a stringent approach to the way in which we interpret the right to consent. The last slide that I want to mention just raises a few key challenges and opportunities that I think are quite relevant. We know that the borderless nature of social media platforms gives rise to complexities. And in particular, we have a challenge with an issue of jurisdiction. Here, I think jurisdiction and scope are going to be one of the key determinations that the information regulator is going to need to make in terms of what is in giving content to Section 3 of PAPIA, in understanding whether or not social media platforms that are incorporated outside of South Africa fall within the jurisdiction of the information regulator in South Africa. But I think Section 3 is drafted quite broadly, and there's a lot of scope in there to really test the mandate of the regulator. We've seen some voluntary compliance with local authorities, for example, the Competition Commission, where Google and Fitbit were subjected to a merger, an assessment of the merger between the two entities. We've also recently seen an instance of WhatsApp and GovChat being determined by South African authorities. And so whether that's done on a voluntary basis or a cooperative basis, or because they fall strictly within the jurisdictional elements of the law, I think there's a really crucial opportunity here to test the ambit of the regulator's mandate. I think imperative is that we need specific guidance regarding children, because the rights of children and the best interest of the child is imperative in the work that all of us do as privacy advocates. And there's a need for ongoing review and updates. If you take into account that PAPIA was drafted before the first smartwatch was available on the market, it's time perhaps already, despite the lengthy delays that we've already seen, to start thinking to the future and understanding whether some of these provisions need to be revised to understand the current context in which we find ourselves. And the last point I want to make is really a clarion call to all of us on the call to work with the regulator in strengthening the mandate, in facilitating appropriate cases, and in raising awareness about the different challenges that privacy presents, and making sure that the broader public, members of the public, are aware of their rights and can successfully and effectively vindicate their rights by using the mechanism of the information regulator. That's it. Thank you so much.
Thank you so much, Ms. Singh. Thank you so much for giving us such a good presentation and really outlining the importance of protecting the right to privacy and how it's a business imperative thereof. And I think it was very enlightening that you even shared those four highlights, the four conditions that you highlighted for lawful processing, because it also assists data subjects to know what is it that businesses, what are the safeguards that businesses need to put forward and the security, so that we are able to know when our personal information is actually being exploited. So we really appreciate the reflection that you have made. And what I'm going to do right now is that I'm going to allow some engagements from the participants to engage with you on your presentation. What I'll do is that I'll allow for maybe 3 speakers who would like to raise their hand, and we'll allow them to ask their questions. But maybe before that, Ms. Singh, I'm just going to read out 2 questions that were posed on the chat room for yourself to note. Then I'll take the 3 speakers on the floor, and we will then allow you to interact on those comments or questions that will be raised. We have a comment that comes from Nandipa Njaluba, who says, it is so true and it is so unfortunate that we have not yet implemented FOOS in South Africa to develop our own platforms with all the expertise we have endowed with. And then we also do have, I think that was basically a comment, but we also have a question from Muchengeti Haucha. Please excuse me if I did not pronounce that correctly. They say, hi, Avani, please advise on whether the Belgium example of sharing the data of a friend with a company would be permissible under the POPIA framework. I think those are the 2 that I have for now. If there are any on a later stage, I will allow for other engagement, but perhaps I can just note here that Emma Sadlia says that she absolutely appreciated your presentation and what you have just outlined. I do see a hand from Mabato. Mabato, please can you unmute yourself, and kindly can I give you just a half a minute to pose your question? Thank you.
Hello, everyone. Can you hear me?
Thank you, Mabato. You are on. Can you go ahead?
I'm actually... No, my name is Tebo Kostatu. I logged on using Mabato's account.
Okay,
Tebo.
Yes. Go ahead, Tebo. We apologize.
Thank you very much. Thank you so much for this engagement. And one wonders why the information regulator is the least known government agency or regulator in this country, why it's so important. But I want to thank the host for really organizing this kind of thing. I come from the music, the creative industry, so to speak, being in music for the last 23 years. And as you know, the music industry has been disrupted. The creative industry has been disrupted. It's you see, back in the days, we used to sell CDs. Started with records, LPs, 45s, vinyls, CDs. Before CDs, cassettes. Now everything is online, and I think this discussion is so important for my sector. Once I saw the poster, I had to attend. And I'm not really, it's not a hit and run kind of thing. I would like to reconnect with you guys. Avani, thanks for the lovely presentation. Because as the creative industry, we use social media. You know, artists across the board, across the world, social media is a big thing to sell our product. So our content, and there's so much that we need to talk to. But also, I belong to the circle of the collecting societies, what we call the collective management organizations. So we've just qualified as the first intellectual property, for level skills 5. So we're starting an IP academy. So I see a lot of connection between the regulator and ourselves. And one of the visions I have is to actually host a conference with you guys as an information regulator, because we get paid by the royalty collecting societies based on information on data, and I obviously is it Nozondi? Are you our host? I suppose, because you're chairing the session. Yes. So I'd like to connect with you guys and see because of this will actually help you in, because of I saw in the slide, one of the slides by Avani, that there's advocacy and awareness. So our partnership will assist you reach out to a much more bigger audience, especially of young people. As you know, young people are the dominant people in the creative industry, musicians, actors, authors, and stuff like that. But yes, I just wanted to say thank you very much for this engagement, and I'd like to connect with you guys, especially the panelists beyond after here, and then we can take it from there. Thank you so much. Much appreciated.
Thank you for that, Deboho. We really appreciate that you have joined the platform and you found it very, very useful to yourself. And we are looking forward to further engagements thereof. We will be sharing our details so you can further reach out, and we will definitely also connect and collaborate with yourself. Thank you for that. I'm just going to check if we do have another hand from the floor with a question for Ms. Avani. If not, I don't see a hand for now, but can I just go to the chat room and allow for these two questions? I'm going to read out two questions from Shelly and Nontik. I'm going to just assume it's Nontikelelo, but it's non-SK. I'll read those two questions out, and then I'm going to allow you, Ms. Avani, to interact and engage with those comments that have come forward. So Nontikelelo says, will consent from employees be sufficient for the law processing personal information? And then Shirley also then asks, what information should a consent request include? So Shirley asked, what information should a consent request include? So those are the two that came through from the chat. So I will hand over to you, Ms. Avani Singh, to then engage with Deboho and those questions that I've read out from the chat. Over to you. Thank you.
Thank you so much. So I agree fully with the first comment about the opportunities that there are for developing local platforms. I think that that would be quite an exciting space for local developers to kind of delve into, and we're starting to see more and more across the continent really promising developments of privacy protecting social media platforms, chat applications, and so on. Which are really gaining traction. So I think those are really positive developments. In terms of the question, in terms of Getty's question regarding the Belgian DPA and whether that would be permissible under the POPI framework, what was interesting in that case was that people voluntarily chose to share their contacts with the platform, but in doing so, they weren't properly informed that that information would be unsold to other third parties to use that information for marketing purposes and other things. And I think similarly that would not be permissible under POPI and the current framework that we have in place. And the principles that were relied on in terms of assessing that complaint are just as applicable under the South African framework. So the same conditions would apply equally. And then on the last two questions, I think the one thing we often say to clients and in general is that consent is not a silver bullet. It's a helpful way, it's a helpful justification, and it's certainly something, we encourage a consent-driven approach to data protection and processing activities. But it would depend on how you craft that consent. And that goes to the second question as well, as to what information should be shared with the data subject or your employee or your customers or whoever that is. It's a bit difficult to give you a generic answer because I think it's so unique to a particular organization, but Section 18 of POPI is really useful in this regard in terms of what data subjects should be informed of when information is being collected. That's the one. And then the second, I think, which is critical, is that the purpose of your processing activities needs to be stipulated and specified as clearly as possible, and not in a generic way that kind of groups together the different processing activities, but really goes into some detail. And that can seem like a laborious task, but it's actually quite an important component of POPIA and data protection frameworks. And I think will be something that data subjects will expect from responsible parties going forward. I think those were the questions. Thank you so much.
Indeed. Thank you so much, Ms. Avani. That was absolutely brilliant. Thank you so much for that. We will have an opportunity later on if people do have afterthought questions or interaction based on your presentation. I think without wasting any time, I would like to actually introduce and invite our next speaker to the floor. We have Mr. Murray Hunter, who is a communication consultant and a digital rights activist in South Africa. And he has worked previously with the Right to Know campaign and Open Secrets. He has extensively on communication surveillance and is also the author of Boris the Baby Bot, a children's book about data privacy. I see a connection here because Ms. Avani as well in her presentation, she kept alluding actually to data privacy and protection, particularly to children. So quite interesting that there's also that connection. So Mr. Murray Hunter, we'd like to invite you to the floor to actually speak to us or enlighten us with what is metadata and why is it important to protect it, and also to tell us why is it also important to ensure lawful processing thereof. But we would also like for you to share with us about end-to-end encryption and what is the implication for surveillance and the law. We actually have been getting some interesting questions on our Twitter page about surveillance and the law. So let's hear what you have for us today. So the floor is yours. We welcome you, sir. Thank you.
Morning, everyone, and happy Privacy Day, happy Data Protection Day. Look, I think maybe just because the conversation started because there has been a lot of discussion in recent weeks about what's happening with WhatsApp. And I'm sure that there are people on this call who are information lawyers or technologists who are maybe tearing their hair out because you know, the current changes to the WhatsApp privacy policy, I think in some cases, because they have been difficult to understand, some people have been pointing out that the actual changes that are under discussion are not necessarily that controversial. But that almost misses the point, because what is changing with WhatsApp privacy policy doesn't actually significantly change the amount of data that has been collected about you by WhatsApp or shared with Facebook. For most people, there isn't a significant change, but that doesn't actually reassure us, because what that obscures is that WhatsApp is already collecting too much data about you and is already sharing more of that data with Facebook than most people are comfortable with. And what has really happened is this latest discussion around the policy change has actually kind of brought to a head people's growing frustration and discomfort with the way WhatsApp is really, the biggest or one of the world's biggest communications platforms has been drifting in one particular direction towards becoming less and less respectful of the users' data. So the question is, what is metadata? I think Alison and Avani have both spoken to this, but when most people talk about their communications privacy, what they are often thinking about is the privacy of what it is that they say, what we say in our messages to each other. What is the content of, what I say over the phone, what is the content of my SMS? But that is not the only data that is generated when we do a communication. So I always like the metaphor of a letter in an envelope, if anyone remembers letters. And so the content of my communication is actually the letter that goes in the envelope. The metadata, the information about that communication, is everything that goes on the outside of the envelope that says who's sending it, who's receiving it, often our locations when we send it, time and date that it's sent. And that doesn't sound that controversial when you're talking about a single envelope. But when you have 2 billion users, as WhatsApp does, and many of us are exchanging dozens or hundreds of messages a day, what that does is builds up an incredibly detailed sense of who we are, who our networks are, who we communicate with and when. And that actually creates a very detailed insight into who we are. So unfortunately, I don't have a presentation today. I was hoping to be able to show you, I'd recently requested in the lead up to this webinar, I'd done the request through the settings page in WhatsApp for WhatsApp to send me the data that it holds about me. And it takes several days for that data to be processed. So it will only be ready in a few hours apparently. But I've looked at it before, and what it includes is essentially the list of the more than 1,000 phone numbers of the people I communicate with on WhatsApp. And it includes the names of all of the groups I'm in. It's a few dozen groups, I suppose. And includes various other kinds of information, the device I use, which is identifiable to me, my IP address, which is basically my location on the internet. But it is very jarring to see that list because, I mean, in my personal case, of those 1,000 people, there's several people who are actually on this call who are listed there. So unfortunately, your number is stored on WhatsApp server because I've saved you in my phone. That list includes journalists. I suppose because of the work I've done in the past, it includes people who might be whistleblowers. It includes people who are elected officials. It includes people I'm in, my family members, someone I'm in a romantic relationship with. I don't know who they are, but it almost certainly it includes addicts, it includes sex workers, it includes Christians and atheists and people who vote for all political parties and people who don't vote, etc., etc. Each of those people, if they have WhatsApp, has their 1,000 or 2,000 or 3,000 people's numbers stored on that server as well. Put together, this creates a very, very detailed insight into who each of these customers are and allows the company to draw conclusions about their wealth, their location, their gender, their sexual orientation, their political views. If you go through your WhatsApp groups, because the name of the WhatsApp group is also stored in plain text, what we say in those groups might be private because it's encrypted. And we'll talk, sorry, I realize we need to talk about end-to-end encryption. The messages we exchange in those groups are private, but the names of the groups and the members of the groups are not private. And so if you're in the Cyril Ramaphosa support group, WhatsApp group, WhatsApp basically has a pretty good sense of where you stand on that issue. And if you're in the Jacob Zuma Fight Back group, again, there's a fairly good conclusion that can be drawn on about, you know, who you are and what you care about. And so when people say, as WhatsApp has, and as some of the defenders have said, that WhatsApp doesn't collect the content of your communication, it can't read it. This is true. And that's what was being referred to by end-to-end encryption. The content of the message I send on WhatsApp is encrypted on my side. It's put into code. It's sent over WhatsApp servers in a code that even WhatsApp can't read. And it's only decrypted, it's only readable when it reaches your device, which means that the content of your communication is fairly secure. But all of the information about who we communicate with, when, where, and the identities of those people is stuff that WhatsApp can collect and monetize. And I think that is a significant problem. And I don't think, by the way, just since some people mentioned Telegram, I'm not sure that that is really a good solution. Now, I think there's some people who say that this kind of information that's being collected is something we all agreed to at some point, either when we joined WhatsApp or when they would have gradually updated their services. And so, you know, if we want to use this service, we have to kind of, it's their house, their rules. And I think that really ignores a question about the fundamental ethics of this business. You know, it may well be that what they do, I mean, I'm certain what they do will, with a few exceptions, will pass the thresholds that are set by the GDPR and by POPI. They've got 1,000 lawyers who've worked on this, and I'm sure that they will find ways of ensuring that, by and large, this business passes the test of the regulation. There's a bigger question about whether what they do is right. And I think that's really, I guess, the challenge with data protection regulation is that it can enforce some rules of the road, but there are, you know, it can only go so far. And a lot of that then comes to ordinary users and what we're willing to stand for and what we're willing to stand up against. One of the challenges as well is, you know, Alison spoke a little bit about the size of these companies and almost the fact that many of them are coming close to being monopolies. It would be fine if there's 5 pizza places in town and you don't like you don't like the service at one of them, you can walk out the door and you can go to one of the other four. But a communications network doesn't work like a pizza joint. A communications network like WhatsApp or like Facebook or any of the others only works when there's the network effect. It's those communication networks only connect us when there are a sufficient number of users on that network. And at the point at which you reach 2 billion users, in some ways you are in a position where you can hold a lot of your users hostage, because there's a gamble that says that not enough of us can go to another service to make that service viable and believe this. And I think that for those who've been exploring alternatives to WhatsApp in the last few weeks have probably experienced that. It's very difficult to have a conversation with families, with friends, with your work colleagues, to say, listen, this situation is becoming uncomfortable for me, and I would suggest we would like to go try out another service. You can probably get 10% of your folks through, but much harder to get everyone through. And I think that when we look at regulating these big companies, it can't only, it's very challenging when we're speaking about only the extent to which they meet this basic test of regulation without looking at the size of the company and the fact that that determines a huge amount of the power that they have over users. So that makes me think that breaking up some companies might be another form of effective regulation that we might want to talk about. But when we go back to this question of the extent to which these companies protect your data, when they say the content of the communications is secure, that's great to hear, but I think we need to change the conversation so that users understand that that should be the bare minimum. That should be the basic standard that everyone needs. We need to talk much more about the data they collect about the users other than the content, because that is where the value that they derive from their users comes from, because that data is very sensitive. I just want to share one infographic, which I just did as we were speaking, because I think it is a useful indication of the extent to which, in fact, most companies and most authorities are, in fact, much more interested in your metadata than in the content of your communication for different reasons. And there was just some statistics we were able to pull together recently. You should be able to see this. Vodacom, as one of the 4 big telecommunication networks, was asked how many court orders it had received from the police and from state security to intercept the content of people's phone calls from year to year. And in 2018, basically, the police asked to listen into about 500 users' phone calls. And then they were asked to say how many times they'd received court orders for access to those people's metadata, their phone records, the identity of the account holder, that sort of thing. And it was 22,000 just in 1 year. And now if you can replicate that across the industry, you can see that, in fact, there's a lot more interest in people's metadata than the communications. And one of the problems there is that our laws, now this is not POPI, this is our interception and surveillance laws, have always assumed that the content of people's calls is much more sensitive and needing much more legal protection than the information about those calls. And I think there's an increasing realization in 2021 that is a very, very outdated set of assumptions. So if there's anything to come out of this discussion, and I'm concluding now, Chair, it's that as users, we have to change the terms of the discussion around what privacy means and what needs to be private, because the technology companies are not going to set that, are not going to set the terms of that conversation in our favor. And in fact, unfortunately, historically, regulators, legislators, and the authorities are not are still catching up to the modern reality of what data protection should mean and what needs to be protected. Thanks, Chair.
Thank you so much. Thank you so much, Ray Hunter. That was absolutely amazing. I do see you clapping hands, Alison. And if you were in a boardroom or a room as well, we would have really gave a round of applause. But thank you so much for that. It is very interesting what you just shared with us. The analogy of the envelope just made it very clear because we were all having a mental breakdown that the new WhatsApp privacy policy, my message to you, Hunter, will be exposed. People will see that information. But little did we know about the metadata, the information outside of the envelope, which is my location, etc., etc. And we're not aware of how that information is also being accessed. So that explanation actually, as the data subjects, to understand the information that the social media platforms. Thank you so much for your enlightening presentation. Participants who would want to raise questions, or if you have any question that you'd like to put forward to Mr. Murray Hunter, I just want to check if we have anything in the chat room from our other hand from anybody. Okay, we have one question, or is it? Yes, it's a question from Sekiohlane Pamodi. Yes, it's regarding WhatsApp terms of service assessment. Okay, I think this one would would also be referring to if one of the members would like to also weigh in. But their question is there a timeline on our assessment to the terms of service of the WhatsApp privacy policy? And particularly in light of Facebook having expressed intention to proceed with the implementation in the coming months. So that is also a question referred to, also not maybe to Mr. Murray Hunter, but to our members as well. But there's also another question from Caroline. Caroline, how do I manage my business use of WhatsApp? As a processor, I should have disclosure, breach notifications, etc. But people contact me via WhatsApp. So what is WhatsApp now? So is WhatsApp now a processor for my business? Okay, sorry, as a responsible party. So that's what is your question. Okay, so I hope we were able to gather that. Otherwise, I can repeat it if it was not very clear. Do we have a question on law? Any hands? Okay, going once, going twice, going thrice. Okay, we will come back to the floor questions. I'm going to allow Ms. Tilly or any other member in terms of the first question that we got with regards to our assessment, and then I will allow Mr. Murray Hunter to weigh in on the other comments that were raised by Caroline and others. Over to you, Ms. Tilly.
Thank you, Ms. Sandy. My difficulty to some extent is that I'm a newbie at the regulator. So there's a background in working on these things that I'm not yet familiar with, and I'd like to hand over to my colleague, Advocate Weapons or Prof. Snail, who are on this call just to deal with that in more detail. But what I can tell you is that the assessment on WhatsApp and their privacy policies is underway. There was a very short turnaround time originally because it was going to be early in February that there was a deadline for accepting the new T's and C's, although, you know, how new they are is another question. But so it is underway, but there is at this point no timeline on our response. In terms of the particularly, and I see that there was another question from Sekwetlani on the issue around privacy related aspects on the development of the various COVID apps. Not currently that I'm aware of, but again, I may not be aware. So perhaps I can hand over to one of the seasoned veterans on the regulator and ask them to pick up answering that particular question.
Okay, I think what I will do now, Ms. Tilly, on that note, that question that was actually raised, thank you for giving me your correct pronunciation of your name, Sikwetlani. We will definitely allow our other members to respond to that question, including the one that you did ask in relation to the government alerts and the registration platform thereof. I will reiterate that question on a later stage so that our members will be able to engage with you on that part. I just want to allow Mr. Murray Hunter to respond to even Caroline's comment or the question that she raised, and then we will move forward. Thank you. Over to you, Mr. Hunter.
So it sounds like Carolyn definitely needs a poppy lawyer, which I'm not one, but luckily there's about 40 of them on the call. So I'm going to dodge that one, but I want to pick up on something that Sekwetlani raised, which is the data collection that's happening around COVID. I think we can all agree that the pandemic has introduced incredible challenges across pretty much every part of the world and across every part of policy. But just because I was researching COVID collection, data collection for COVID contact tracing last year, I do want to raise, I think, that a real concern that that a bunch of policies have been put in place to collect and to store large amounts of very sensitive health data, where it appears that the people developing the policies have often sort of forgotten that the information regulator existed. And this was the impression I got speaking to people in the Department of Health, people within the telecoms, people within justice, to say, well, we've developed this great system and we have to do it very quickly, and actually we're very concerned about privacy, etc. But it would be very important, I think, to see the information regulator making its presence felt. And I think that, science, for example, to see that the regulator is taking Facebook to task on this issue, I think it's always good to see, really to see the muscles being flexed. And to the extent that we have a data collection, a set of data collection protocols set up in April of last year that were meant to last 3 months, and they're really going to be, we're looking at 12 months, 18 months, 24 months. Those emergency regulations really need to be reviewed and looked at quite closely.
Okay, thank you very much, Mr. Hunter. Were you able to cover Caroline's? Okay.
Definitely a question for a lawyer. I'm not one.
Okay, okay. We will definitely interact with that one, Caroline. But perhaps we will also get the response up on our chat room. We will pose the question again so that you do get a response to that question. Thank you so much, Mr. Hunter, for that engagement and interaction. Please do not go away, because we may have afterthoughts that we may want to actually engage you on with at a later stage. But I would like to introduce and welcome now our part-time member, Professor Sizwe Snail Gamtuze, who is going to be sharing with us a guide for responsible parties to take to be compliant with POPIA. So probably that will also weigh in or give some response to what Caroline was actually raising. So Prof. Snail Gamtuze, can I hand over to yourself? Will you be sharing your presentation online?
Hi there. Can you hear me?
Yes, you are audible. You are audible, Prof. Welcome. Thank you for joining us.
Okay. Yeah. No, I think today is not one of those days for presenting with slides, especially after the marvelous presentations that have been before me. I don't think I should try even and compete with that. However, I do want to say that the topic that's been allocated to me, I think, is a little bit misleading. I don't think the regulator has a guide out for responsible parties or intends to do so in any distant future in terms of what the topic says. But I think what the topic was trying to emphasize was the fact that since last year, as we all know, we have the grace period. Now, I mean, I've been going to different platforms and everyone has always been asking me, so what is this grace period about? Is it a period where people can get away with murder and continue not complying? Or is it a period to get on with it, as I say, to get on with it and get compliant? So I think that's more what I would like to discuss, and I'd like to make it a little bit of a more open discussion, because like I said, you know, I looked at the previous presentations just now, and I don't want to regurgitate the conditions and tell you about things that have already in the public space. I would really like to more engage with the audience and see if there are any particular questions that one can answer in terms of the grace period, what the regulator is currently doing, going towards the grace period, because we've really received a lot of inquiries, and I think this is the right platform to do so. So, you know, what I think one should also emphasize that from a legal standpoint of view, obviously, if a client comes to see you and says, look, I have this and this situation, it may amount to a breach of the conditions of one of the conditions of lawful processing. What is my legal position? I can tell you almost 100%, the legal practitioner is going to say to you, there's a grace period. There's a grace period, and even if your actions were wrong, you are not going to be found guilty of anything, you're not going to be fined. And I think that is really the attitude that I think one needs to change. I mean, I'm a legal practitioner myself, and you know, I come from a litigation background where we always say prevention is better than cure. And trying to settle a bad situation is better than going to litigate one. So the point that I'm trying to make is, if you are faced as a legal practitioner that your client, being a responsible party, may be abusing a personal information, especially now in this period going towards the end of the grace period, I think it is our responsibility as legal practitioners, and like I said, I speak for the legal community as I am one myself, it is our legal duty to not just tell people how to get away with it. Data protection is not criminal law. Data protection is human rights, mixed a little bit with the constitution of our land, and that is what it actually is about. So, you know, one really needs to try and make people understand that there's a paradigm shift. I'll always make the analogy to say that in the not so long distant past, there were laws in our country that allowed the state to intercept your communication. Was it your mail? Was it your telephone? Remember back in the days, it was a wire. Apparently these days they don't tap the wire, they do it digitally. But with that being said, is the state had absolute force and power to invade your privacy. And we've now had a paradigm shift in our constitution. I mean, I always get this question to say, does South Africa follow the GDPR? I think it would be nonsensical of anyone to not consider the GDPR, to not refer to the GDPR, to not find guidance from the GDPR. But we are actually quite lucky, you know, the right to privacy is in our constitution. And I always say that the right to data protection should be considered as a sub-facet of the right to protect your privacy. So what one really needs to do now in an organization, is to change the entire mindset. I mean, let's look at situations like where a data breach has occurred, and one looks at the causes of the data breach. In most instances, it is due to lack of training, due to lack of processes within the organization, due to lack of caring. Nobody cares. It's that POPIA thing. There's a grace period, you know? So what is wrong with that attitude is that once POPIA is now fully in place, in terms of enforceability, right? People are going to be learning some very, very, very hard lessons. And I think forums like the one we have here today are not here to scare people and to say, look, if you don't comply, you're going to get into trouble, et cetera, et cetera. No, it is literally a paradigm shift. We need to start respecting each other's privacy, inter alia, the personal information of data subjects. And responsible parties must now know that they have a legal duty, not just a moral duty, but a legal duty to protect whatever personal information that they interact with. In other words, the word we use is processing. So, you know, it's really not only the responsible parties that need to get their houses in order, but I think even us as data subjects, we make ourselves vulnerable. We put our personal information out there. We put up our profile pictures. We put up our statuses. We put up our comments on Facebook, knowing very well that it's on public mode and not friend mode. We really tell the whole world what we are doing at whatever time we are doing it. I mean, the other day I watched my favorite channel, Crime Investigation, and they were literally investigating a crime, looking at the deceased's Facebook posts, videos that the deceased was posting, and by tracing back these posts and some of the comments that this lady made, the police was able to determine that in actual fact, the husband had something to do with it. So I don't want to detract from the topic and go into criminal law and that, but what I'm trying to say is we as data subjects also, we put our personal information out there. It's not like someone puts a gun to you and says, you need to load that particular app on your phone. In most cases, it's because you want the app, you want to use the app, it makes your life easier. I mean, I'm not condoning the non-compliance of whatever service provider with the POPIA, but I'm just saying that we should also make it a point that in telling responsible parties to protect our personal information, we as data subjects should also literally go out of our way, educate our children, educate those that work for us, that data protection is a reality. I mean, I always give this scenario to say that, you know, in an attorney's firm, you have those old school files, those files with the rubbers, and you end up having 5 or 6 files on your table because you're trying to work on this and you're trying to work on that. And then the client comes for consultation. And I think for a very, very long time as a junior attorney, I wouldn't mind having someone else's files on the table whilst I'm consulting with the client. But now, like I said, it's a mind shift. Now, when another client comes in, that table must be clean. You know, we don't want this client knowing that, oh, Mr. So-and-so who drives a beautiful Mercedes Benz is actually owing the bank, because that is that from a file just sitting there. So, you know, like I said, I want to make this an interactive session. I would really like to get some comments from the floor and see if I can answer some relating to, like I said, the grace period and us getting there.
Thank you very much, Prof. There you have it. We are wanting a very interactive engagement on this topic. on the subject matter. So I am not going to waste any time to try and summarize what Professor was saying, but this is absolutely the opportunity for us to all engage on this particular topic and raise the questions that we may have. And Prof will be responding, and with the assistance of other members that are actually on the platform. So this is an opportunity now for the hands to be raised, and we will allow you to then engage on the topic. Thank you so much, Prof, for that. Whilst I just check if we have any questions on the chat room, whilst we wait for the hands to come forward. We actually have Nandipa Njaluba. She asked if can Prof assist with a dummy guide on the ABCs to inform interdepartmental sharing of info in line with the 8 principles and the GDPR. Just going to go through a few for noting, Prof. Then I'll allow for some interaction whilst I wait for any hands that may come forward. Then we also have Bilal Bukhari, who then says, with regards to cross-border transfers for purposes of Section 72 of POPIA, will the regulator be publishing? I apologize for that. My cursor just moved rapidly. Okay.
Let me help you there. Will
Please
the
do, Prof.
publishing an adequacy list? If so, will the EU be deemed adequate despite the fact that their legislation does not apply to PI of juristic persons?
Yes.
Are you again? Can I give over back to you, or should I read the rest?
Since you're on a roll, let me allow you. You can continue, Prof.
I see Nandipa Njaluba, POPIA principles that situate in the GDPR to guide the triangulation of personal data within the state. All right. And then I see here a comment by Funo. There seems to be no awareness or lack of sense of urgency when it comes to readiness of organizations to implement and comply with POPIA. Does the information regulator have awareness programs that are intended to ensure that organizations understand that POPIA implementation is not an optional extra? And then there's another one. Do you want to talk to the unconstitutionality that was declared to some sections of RICA and implications on privacy? That's all from Nandipa again. Then there's a question from Dale Adams. Does the information regulator have jurisdiction to investigate matters arising during the grace period after the expiration of the grace period? It's an interesting one. Yeah. And the last one is from Caroline Mouton. What is the actual consequence right now if a data breach is not disclosed? Is civil action an option right now, and will complaints to the regulator, let me see, can complaints to the regulator be lodged now? Every consequence after the 1st of July. I see a comment from Kevin Hoole. Advocate Snail, to what degree will the information regulator apply the concepts of the GDPR and the views of the EDP, considering the differences between POPIA and the GDPR? There are many examples, but one is consent, such as defined in the GDPR as requiring an affirmative action, but this isn't specifically required in POPIA. Will the IR require it or not? And then Junitas, we're concerned with the requests from other entities such as SARS requesting client information. We could appreciate guidance on the link between POPIA and government requests. So I think we need to start from the beginning of when I started. So the first question pertained to the ABC for dummies, I think, to inform interdepartmental sharing. I think that's a very interesting question, and I think if you really feel strongly about it, Advocate Njaluba, maybe you should formally approach the regulator and see where that particular discussion can go. Then there's the question from Bilal Bukhari, the one about cross-border transfer. Will the regulator be publishing an adequacy list? As it stands, the regulator has not considered an adequacy list, but I think it's a nice to have, and I think it's really something that the regulator should consider. So I'm talking to my colleagues now to say, I think this is something that we really should look into in terms of that. And then if so, will the EU be deemed adequate? I think if a list will be there obviously will be a test as well. So I think that's something I can't answer at this particular platform. But I think the idea of a list is not a bad idea. Then once again here from Advocate Nzaluba, POPIA principles that situate within the GDPR to guide the triangulation of personal data within the state. I think that was more a comment. Then I see here from Lufuno T, there seems to be no awareness or lack or sense of urgency when it comes to readiness of the organizations to implement. Yes, I think it goes back to what I was saying, that the grace period is seen to many as a period not to comply, a period for you to get away with it, not to comply, and hopefully when compliance is fully effective at the end of the grace period, they won't catch me or I will get my house in order by then. So yes, awareness is key. I think even from the regulator's perspective, awareness is the driving force to really make sure that everyone, and not just the private sector or people who are professionally or monetarily affected by personal information, but also the poorest of the poor, those whose personal information is abused the most. So I think that's an adequate answer to that. Advocate Stroom or Alison, do you want to answer the next one? I see there's one more comment here on, do you want to talk to the unconstitutionality that was declared to some sections in RICA and implications on privacy? Okay, I think that's also, as much as a question, it's a comment. Maybe I should throw this one to Advocate Stroom. Does the information regulator have jurisdiction to investigate matters arising during the grace period and after the expiration of the grace period? Advocate Stroom?
Thank you very much, Program Director, Ms. Zondi, and thank you very much, Prof. I think we have discussed this issue before, and it's a legal issue, which, I mean, does the law apply retrospectively or retroactively? And I think we spoke about this and in our interaction as the regulator to say, come the end of the grace period and the Act is in full operation from the 1st of July this year, what do we do with the complaints or any transgressions in terms of the Act that happened before the actual commencement of the Act? So I think we left it there because for now, what we do, the Act mandates us to for example, in complaints, to investigate those complaints, but we can't do anything because those enforcement sections are not yet in operation. But I think it's something that we need to come up as a regulator with a decision, because remember, the Act was faced in stages. So the whole Act didn't commence as a whole from 2013. It was certain section commenced and the others now are going to be fully implemented 1st of June. So we should have a principled decision in terms of law as the regulator to see how we deal with transgressions that happened before the end of the grace period and going forward, how we deal with those transactions if they are continuing even after the grace period. So I think that's where our interaction as internal as the regulator, a decision in terms of the way forward legally and as the regulator in terms of how are we going to move forward with these issues, because we can't just leave complaints that we received before the grace period open. So we need to really unpack that. If you remember, Prof, we talked about the issue of application of the law retrospectively or reactively in terms of POPIA. So we need to come down to that principle decision. Thank you, Chair.
And then there was another question here. One of the actual consequences right now, if a data breach is not disclosed, is civil action an option right now, and will complaints to the regulator lodged now carry any consequence? Is there any member who would like to answer that one? All right, I think I'll answer it then. The regulator has really taken the position of proactive notifications to the regulator. And, you know, in some of these public interest data breaches, the regulator has actually tried to use its limited investigative powers to try and get to the bottom of what happened and try and assist those responsible parties with doing correct notifications to data subjects. But in terms of fines and other remedial action, I think during the grace period, that shall not be so. But I can assure you that the regulator, as of 2019, we've actually had a breach register, and a lot of responsible parties actually have been proactively reporting. And over the years, we have actually developed several things, such as templates for notifications for responsible parties and things like that, assisting them with dealing with their data breaches as well. So let me go to the next one. I don't want to sit too long. Okay, this one is addressed to me, Advocate Snell. I'm actually an attorney. To what degree will the information regulator apply the concept of the GDPR and the views? Oh yes, I saw that one. I think Mr. Hool, we once again are guided by the Constitution here to say that, you know, in the event of the information regulator having to interpret any of its own laws, in other words, in interpreting the POPIA, the Constitution is very clear that we may look at foreign law, we must look at international law. So, you know, as I said earlier on, the GDPR, as much as it's not the Bible for us, it is an interesting source of international law, of international best practice, which one can look at. And I think some of the cases that have been decided there by the European Court of Justice really show the practical application of the data protection framework and how it really works. All right, we have here Juanita S. We are concerned with requests from other entities such as SARS requesting client information. Advocate Strum, can I ask you to deal with that one?
Is the question, Prof?
The question, we are concerned with requests from other entities, such as SARS, requesting client information. Would really appreciate guidance on the link between POPIA and government requests. That is from Juanita S.
Yeah, a very interesting question. As you're aware, Prof, at the moment we're dealing with tax information on one of the cases that we're analyzing, because in terms of POPIA, financial information amounts to personal information. So we need to come to a decision in terms of how unpacking, especially not only POPIA, PIA, in terms of access of records and also POPIA, because in terms of POPIA, tax information is personal information, and vis-a-vis in PIA, can you request access to that kind of a record? So I think there's a balancing act there. And I think we were in a process in our legal department to unpack one of those cases that dealt with, is in the public domain, with access to tax information. So we need to come with a position after we have unpacked our opinion to say, how do we, because in terms of there's a section in PAIA which regulates access to tax records, and also POPIA vis-a-vis POPIA on the other hand is of the view that tax information amounts to personal information. Thank you, Prof.
All right, then we have another comment here from Lufuno T. Due to COVID-19 regulations, we are required to sign in when we visit different government premises. I'm always concerned about the privacy and security of personal information that is being processed. Has the information regulator issued guidelines in terms of how this processing should happen? Let me see, should happen in compliance with COVID-19 regulations. All right, the information regulator actually quite at the early stages of the COVID-19 pandemic issued a guidance note on the processing of personal information, trying to align the POPIA with what the government at the time was using as the interim legal measures pertaining to the combating, or should I say the fight against COVID-19. The guidance note can be found on our website. It would be good if you interact with that. Then the next question here, let's see. Okay, there's a comment here from Murray Hunter. Chair, may I respond about the RICA query? So I guess that's for you, Murray. Maybe you should answer.
Prof, can I request, Prof, that in regards to the questions that were directed to yourself, if we can read the remainder of them out and then we respond in summary to those. And if there were any questions or queries that we may have left out, there will be another segment where we'll allow for engagement. And then once you've done that, we'll ask Mr. Murray Hunter to weigh in.
Yes, I'm looking at time as well, but yes. I mean, he's on the line, so maybe let him just answer that, because I see it's 10 more questions here. I don't know how far we can go in answering those. Let Mr. Hunter the courtesy just to answer that.
Sure, okay, Prof. I'll be brief. Just to say that the RICA judgment, obviously, it's still pending confirmation or ruling by the Constitutional Court any day now. But it's important to note, if the High Court's ruling that certain parts of RICA are unconstitutional, it would improve transparency and add some additional safeguards in interception of people's communication, but only a very limited type of interception, which is the interception of people's content of their communications or their metadata in terms of RICA. But you'll remember that infographic that I showed earlier, sort of spoke to the fact that RICA interceptions are actually only that very small 500 a year, 600 a year types of requests, but there are tens of thousands of requests. In fact, we think about 1,000 court orders being issued a week from the magistrate's court for people's metadata, which is not affected. It's not done through RICA and it won't be affected by the RICA judgment. I think that the bigger question is, how does POPI apply to national security agencies? Lots of POPI lawyers here who will point out that they're exempted, except when the data processing is, only when the data processing is enabled by another law which does have privacy protections. And I think what we're seeing in terms of various kinds of interception that the state is doing, in terms of security policies that include biometrics from Home Affairs, etc., those privacy protecting laws are not actually in place. And so to some extent, it would be interesting to see the regulator getting more involved in that space to say, what is the state doing that actually is a national security policy that involves data collection, but where there might not be adequate privacy safeguards involved. And just one final point for the chair is that given the complexity of these discussions and how complex data protection questions are, obviously this kind of proves the point that we can't put too much of the expectation on the data subjects to understand this. In the same way that I don't know how much fluoride or arsenic is in my tap water, I really rely on a few expert officials who put in place by the state to protect me against polluted water. I think a lot of the data protection challenges really does fall to a small group of hardworking people such as yourself to solve, because ordinary citizens can't be expected to engage with this day to day. Thank you.
I think perhaps if
Mr. Hunter. Thanks a lot for that response. Ms. Tilly, sorry, I spoke over you. You can come in, ma'am.
I wanted to just chip in there to say that I know that there are a lot of questions that we've had which are unanswered. Regulator has an education and communications portfolio, and I've been given the privilege of leading on that committee, and I'm hoping that we will be able to have more engagements like this, so that we don't have to try and get everything in today. If you will save up your words and put them aside, and if we are not able to get to them today, we will be having more engagements going forward. So yeah, just to say, if you're not answered today, it doesn't mean the issue won't be dealt with. It just meant we may not be able to do it within the time we have today.
Thank you, Ms. Tilly. You just saved me. Thank you for sharing that. We are definitely recording everything, and we are going to try our level best to be responding to all the queries that we may have missed. Since we are hot on the wheels in terms of the information regulator and our functions, why don't I just allow Advocate Lebogang Strunzama to actually come to the floor and share with us what is the effects of POPIA amending PAIA. So Advocate Strunzama, I would give you the floor, and nothing gives me anxiety like saying, oh gosh, look at the time. But I will allow you to take us through your presentation, and we will have engagements thereof. Thank you very much, Advocate. Over to you.
I think Member Storm, it's on mute.
Oh yes, I wanted to notify her.
Sorry, Miss Zondi, about that. I was trying to share my screen with you, so I'm having challenges in moving my screen. Okay, now I'm fine. Thanks a lot, Ms. Zondi, Program Director, for this opportunity. I'm the last speaker. I think I'll be talking about the effect of POPIA on amending, the effect of coming into operation of POPIA in amending PAIA. As everybody's aware now that the regulator is one of the regulators in Africa with a dual mandate. We are responsible for two rights: the right to access to information, which is POPIA, and the promotion of access to information, which is PAIA. And as we are aware, the PAIA function is currently with the South African Human Rights Commission. And as we know, history will tell us cases like the Western Cape High Court decision of My Vote Counts case was that PAIA has been around for almost 20 years, but there are gaping holes that were identified by the court in PAIA. So coming to operation of POPIA 1st of July this year, we'll see section 110 of POPIA kicks in, which deals with the amendment of laws, meaning now the amended section in PAIA by POPIA will take effect. Now, to be ready for that process, section 1144 of POPIA give us the authority to take over the PAIA mandate from the South African Human Rights Commission. So what we have done till to date is that we have entered into a memorandum of cooperation with the Human Rights Commission, and we have put those elements in terms of the transition period and the takeover in that MOC. So we've got a plan of action in place, and then we want to sort of, in the meantime, from now, start implementing some of those functions in the MOC, so that come the 1st of July, we take over that function from the South African Human Rights Commission. Now, one of the salient features that will come once POPIA amends PAIA is our Section 10 guide, which is now with the Human Rights Commission. It's an existing guide that we need to take over and update it, and we are in the process of updating that guide. The Section 14 manual, also there are requirements in terms of the new amendment, in terms of how the manual should, what the manual should entail. Section 15, for an example, deals with voluntary disclosures, and it mandates you, it tells you how you need to manage those disclosures and the process thereof, which was not in PAIA initially. Section 22, which deals with fees by public bodies, and you'll see that the issue of fees now, you need to have a prescribed fee in order to comply with the new Section 22 as amended by PAIA, and we are looking at those fees. The issue also of internal appeals. If you are not happy, a requester or a third party is not happy about the decision of an information officer of a public or private body, you can now come to the regulator before you can go to court. So one of the remedies that POPIA is bringing is that there's those internal mechanisms in terms of resolution of these issues. So you'll see now that initially, if you are aggrieved by a decision of an information officer in terms of PAIA, you just have to go to court. I think those one are ones of the challenges that we had with the Act, because what about people who can afford? But now POPIA is bringing the remedy to say now, before you can go to court, you can come to the regulator as an aggrieved person in terms of Section 74 of same as Section 74 of POPIA. Come to the regulator. We've got an enforcement committee in house to deal with those issues before you can actually go to the High Court. Section 32 reports, which are reports that usually were the reports that we submit to the Human Rights Commission. So those reports now will be reports to the regulator. Section 51 manual, also there are new requirements in terms of how we need to comply with what we need to have, the manual needs to contain in order to comply with Section 51. And also there's Section 54 fees in relation to private bodies, those prescribed fees that the regulator will also prescribe in terms of fees. You'll see the difference. 22 deals with fees by public body. Section 54 is fees by private bodies. Now, in terms of the enforcement mechanism, you'll note that the remedy that came into PAIA as amended by POPIA in terms of the enforcement mechanism mirrors the enforcement mechanism in Chapter 10 of POPIA. For an example, the new Section 77 capital A in PAIA, it tells you how to deal with complaints to the regulator, also in terms of Section 74 of POPIA. And Section 77 capital B, the modes of complaints that you can submit to the regulator. And then Section 77 capital C, what the regulator can do in terms of when they receive the complaint. They can either look at the complaint, attend to it, or if they feel that there's no ground, it's frivolous complaints, they can actually advise accordingly. Section 77 deregulates the fact that the regulator may decide to take no action at all on the complaint. Maybe let's say the complaint has to be dealt by another regulator, not the regulator. Section 77 capital E, it's our pre-investigation proceedings in the regulator. This come up now as our internal enforcement mechanism. And 77 capital F, it's settlement of complaints. We've got mediation and arbitration proceedings internally that we can do to ensure that we settle complaints before we can actually go to court. Those are the internal remedies within the regulator. Then 77 capital G is the investigation proceedings that the regulator will embark on once we have received your complaint. So they are detailed in the amendment sections. And then Section 77H mirrors also the assessment procedure in POPIA, and 77 capital I, the issuing of an enforcement information notice, 77 capital J, the enforcement notice that the regulator can issue, and the consequences in terms of section 77 capital H on the non-compliance with the enforcement notice. So if you look at this enforcement mechanism, they mirrors the remedies that are now in POPIA. So by this way, you can see that the gap that we're in PIA are now going to be remedied for as of the 1st of July, with this new dispensation of the new law coming into operation. So the POPIA has, to a certain instance, remedied those gaps that were initially in PIA for the past 20 years. And the other section is the section 78 applications to court. It echoes the very sentiment in the enforcement mechanism to say, now there are new sections that are inserted that were not in the initial PIA, which is section 78, 1 and A and B. You'll see that the difference is that you need to approach the regulator before you can actually go to court. So they sort of echo the enforcement mechanism to say, now, if you have a complaint, the regulator will intervene before you can actually go to court. And if you are still aggrieved by the decision of the information regulator, is then you can approach court. So actually your section 78 application echo the fact that yes, indeed, this enforcement mechanism are now in place because there's the information regulator who you can approach before actually going to court. And as we continue, the other change will be the section 83, which is the additional functions of the regulator. You'll see in the old PIA, it was the additional functions of the South African Human Rights Commission. Now there's more additional functions of the information regulator, and 84 is the new section, which is the report to the National Assembly by the regulator. So I've just highlighted on a simple presentation to say these are just the salient features that will feature once the POPIA amends PIA. So mostly it's the enforcement mechanism, because usually people were saying PIA has been around for 20 years, but it doesn't have teeth. You cannot enforce your right in terms of PIA. But now that there's this amendment coming, you'll see that actually the aggrieved requesters and third parties will have recourse in exercising their rights in terms of PIA once PIA is amended by POPIA. I thank you.
Thank you very much, Advocate Lebo, for that insightful presentation. And it is quite interesting that, what you've outlined in terms of the gaps that have been there in the past 20 years in PIA, which now will be remedied as of the 1st of July. Thank you so much for sharing that information with us. I will be allowing the participants to actually raise any questions that they have in regards to your presentation. Do we have any hands? I do see Tebogo's hand up. Tebogo, is your hand an old one, or is it a new hand? Tebogo, aka Mabato. I will allow you to pose your question.
Thank you, Chair. Yeah, very interesting. I'm glad I stayed longer. I'm also part of the civil society movement. Well, obviously coming from the creative industries, we've been very involved in actually a battle, and I think it relates to this question between the balance between protecting the right to the protection of information as is enshrined in the Constitution, as well as the right to the public receiving information because of the public interest matter. So it's a balance, and I'm hoping that you can answer me, because of we actually even going to test this thing in court, wherein you I'll give an example. The exact case in point: the National Lottery Commission funds NGOs, NPOs, non-profit companies. So when they fund an organization, whilst it's important for transparency to prevail, as the regulator, where would you be? What's your view in terms of us as beneficiaries being against our information being published without consent, because of obviously there are processes like PAIA has been in existence. You want information, so be it. Transparency is critical in democracy. Corruption should be fought at all levels. However, do not steal information, as has been the case by specific organizations, especially media, and they would publish it without the beneficiaries' consent, because of then there we are battling between the balance between the right to privacy, because of we live in unfortunately crime is so high that somebody sees your information out there, you receive so much, they start harassing you, they start kidnapping your kids, they start doing this and that. So what is your view as the information regulator in as far as that what of these issues have been in the public domain? Thank you very much.
Thank you very much, Tebogo. Advocates, let me just refer to a question that we have in the chat room from Nandipa Nchaluba. She asks that the PAIA has created, apologies for that, the PAIA has created GITOs that has to fulfill roles that are heavily legal. Can the information regulator deal with the anomaly as part of transfers of function to reposition these in line with competencies and capabilities that are embedded? And I just want to check, and she says PAIA established some national coordinators. Are these still to operate? That's still from Nandipa Nchaluba. I will hand over to yourself, advocates, to engage with Tebogo and Nandipa on those comments and questions. Thank you.
Thank you. Thank you very much, Program Director. I'll start with the first question, which is very interesting because we can't wait. These issues have been playing out in the public domain. It's true. We know about the national lotteries issues that the beneficiaries who have received those funds, do we need to know who are they? Transparency versus privacy is going to be very interesting because, like you said, you're correct. It's a balancing act because it's privacy, it's access to information. But when you look at PAIA in terms of transparency, there's a public interest override element that comes into play. So the question will be, yes, it's my private information, don't disclose that I'm a beneficiary, but however, is it in the public interest that we should know that you receive this fund? And for transparency purposes, because in terms of whatever act that mandates the lotteries, you need to pay this beneficiary in a certain way. There's a way that you cannot just pay whoever. We need to know, you need to disclose to us to say, because I think the act mandates them to say, you need to donate these funds to these charities, to this. So obviously it's transparency versus privacy. And it will be very interesting because we've discussed this issue before as the regulator, but I don't think we have come to a formal conclusion because it's debates. I mean, when you come and say public interest, you are going to another level of engagement, because is it in the public interest to disclose that information? Then the next question comes, for an example, if political parties, a politician, is it in the public interest to disclose a politician's tax information, for an example? So the issue of public interest will play a very huge role, but like I said, this is a balancing act. It's two rights and we need to balance them. So it's one of the exercises that we've been, things that we have been discussing as the regulator at the moment. But I think we'll come with a position. I think some of these matters, I think they will be tested in court, and it will actually give us precedence in terms of how do we move forward with this issue and the balancing of these rights. And I think it's very interesting that you raise this question because it seems well we are taking the mandate now from PAIA. It's very one of the key issues that we'll look into. Thanks a lot. And the next question from Nandipa. Nandipa, we have the regulator and the South African Human Rights Commission have been engaging with this. Is it the national coordination committees? We have even invited them provincially to our stakeholder engagement. So I don't think it's something that we could leave them behind. I think somehow we need to collaborate as part of our stakeholder engagement and cohesion to say we need to proceed, because they have been working together with the South African Human Rights Commission. I take your advice to say it's good that there must be some level of awareness in terms of people who occupy these roles so that they can impart informed information in their organization. So I think we won't leave the National Coordination Committee behind. We will proceed with it because we found them working well with the South African Human Rights. We've invited them on various of our engagement, the IDUA, a lot of engagement. And we do have a list, by the way, of those provincial coordinator and who's involved where, because we have collated that list when we're trying to engage them and pulling them in to say the regulators here is going to take over this mandate from the South African Human Rights. And then I think it's critical that we need to get them together again and see how we move forward with the NCC, National Coordinator Committees. Thank you.
Thank you very much, advocates, for the responses. We really appreciate that and the engagements thereof. Certainly, the number of questions that come forward has raised further debates and discussions. And like Ms. Tilly referred earlier, that we are definitely going to be coordinating more of such engagements so we are able to have such discussions and also engage with responsible parties and the public on issues of the information regulator, BAIA and BOPIA. So I would now actually want to make a note that the question and answer session, we are going to be responding to a few questions that have been raised even on our social media pages. But then again, we are still advising you, if you have any questions that we may have not had the time to actually respond to here, you are more than welcome to actually forward those questions to our email address, as I had shared it earlier on inforeg at justice.gov.za. I did also share my email address, which is nozondi@justice.gov.za, and we will be engaging and responding to those questions that we may have not had the time to engage on this platform. Without any further ado, I would love to actually invite Advocate Colin Whippend to actually give us a way forward as we near the closure of our session today. Advocate Whippend, can I allow you to take the floor at this moment? Do I still have Advocate Whippend on the platform?
Thank you so much, Ms. Zondi. Colleagues, good afternoon. I'd like to apologize for the overrun in time. I'd also like to then also do the vote of thanks and also the way forward. I'd like to thank all stakeholders with blessing us with their presence today, especially taking into account our busy schedules, and also the fact that our guest speakers have also set time aside to also actually provide quite an informative positions on social media and the value of personal information in this regard. What is also very important for us is to also thank all our internal actors or stakeholders, which is Ms. Zondi, who has been directing the program, also Mr. Nemasisi, who has done the opening and welcome, and also Professor Snail and Advocate Sturm. Colleagues and Ms. Tully as well. What I would like to also do is to look at a way forward by also just taking a summary or a synopsis of each of the presentations. Mr. Nemasisi informed the webinar that there will be different guidance notes that will be issued, and those guidance notes would actually help to ensure compliance with the provisions of POPIA. And Ms. Tully also looked at Google and Facebook and WhatsApp and all these social media companies and their value, as well as what we would call their market share. What is also very important was that Ms. Tully referred to the fact that our personal information create the value because that becomes the basis of the transactions that happens within the social media companies and platforms. And there was also a distinction made by Ms. Tully about the product and to state that personal information of data subjects is not a product of that company. And that position is perfectly supported by the Constitutional Court judgment in the case of the Black Sash Trust versus the Minister of Social Development and others. What is also very important, colleagues, is that Ms. Singh also spoke about POPIA and its enforcement, enforcing rights. Also the fact that users must make informed decisions. And then also the fact that responsible parties, which are these social media companies, must also then ensure that they remain accountable. And what is also very important is the fact that there was a very insightful, if I can call it that, position that Ms. Singh highlighted, particularly with the fact that the impact of the WhatsApp policy or proposed policy was a shift in users to Telegram, for instance, which therefore, I would say, if we use the analogy of Ms. Tully, would increase the market value and market share of Telegram. Quite interesting to note. Mr. Hunter also then looked at the fact that there were implications from the WhatsApp policy, but what is also very important was the fact that Mr. Hunter simplified metadata, and then also referring to who's sending information, who's receiving the information, the content of the messages, your location, and also very importantly, the gender, sexual orientation, and all of those things that would, be the type of social, type of personal information that social media companies collect. And what is also very important for us is also to look at Prof. Snail's contribution, which referred to the fact that there exists a legal duty and the fact that data protection is actually a human right. And what is also very important for us to note is that there might be hard lessons to be learned if, for instance, we don't, take our compliance obligations as responsible parties seriously. And that would also then refer to the fact that Professor Snail made an example of the fact that your table must be cleared during consultations, especially if you are in the legal fraternity, because a physical data breach can occur easily if your table is not cleared during consultations. And Advocate Strom referred to in the main in her presentation about the enforcement mechanisms in POPIA and PIA that are similar or the same, which would then make it easy for us during the enforcement committee settings to actually appreciate a singular or similar process for both. Colleagues, the way forward would be that we would definitely look at a summarized report as an outcome of this webinar. What is also very important to note is that we must raise continuous awareness with regards to social media, and also the fact that your personal information contributes to the value of these big corporates. What is also very important to note is the fact that the regulator would need to consider various other mechanisms, including, and this is very important, colleagues, raising more awareness. But we would also know that in the South African context, there's a lot of obstacles and limitations because of the fact that not all our previously disadvantaged users or disadvantaged users have access to these social media platforms, especially in rural areas. And that would make it difficult in a COVID-19 context. But what is also very important for us to understand and appreciate is that whilst we're struggling with physical engagements, the regulator would have to look at more webinars and more engagements on these social media platforms, and also to ensure that there is an engagement taking place with WhatsApp, as Professor Snail, Ms. Tully, the chairperson, and Advocate Strom, as well as my last contribution on the global cable network news, China Global Network Cable News, where we have confirmed that we will complete our analysis and we will definitely engage WhatsApp and Facebook on these policy changes to the extent that we also ensure that at some stage we share our analysis in some shape or form with the public and at large, as well as our stakeholders being responsible parties. Colleagues, I'm going to stop there and say thank you once more for all the efforts and contributions during the webinar. And I'm going to hand over to Ms. Zondi. Ms. Zondi, over to you.
Thank you very much, Advocate Whippen, and thank you so much for that absolutely exceptional closure. I have no further words to share, but I'd like to thank everybody for joining us. And I hope that it was a useful session for everybody. And as I have indicated in the chat room, the webinar video will be available on our social media platforms as well as our website. And I have also shared our email addresses where we can further be reached on. So thank you very much to all our guests and our participants, and to those that are tuning in live on our Facebook. Thank you very much and have a good day. Thank you.
Why do you think there is a problem they don't really want to go along with it? Thank you for that question, Yusuf. So I'll start off by pointing out that there is a convention, the titled Cybersecurity and Personal Data Convention in the African Union, that talks about measures that should be put in place to protect that. And this convention has been agreed upon by the members of the African Union, by large the African